I'll go live. Let me just get it onto. I think there we are. I think we are live. Okay, welcome everyone on our webinar dealing with mediation and parenting plans, or parenting plans and mediation. With me, none other than Daniella Mair. She's a psychologist, a counseling psychologist. She's an expert in family counseling issues. So if you have a problem regarding your marriage or contact and care issues, she is a person to go to. And on screen, she cannot see it unless she's on Facebook now. You can see her details: Daniella Mair, a psychologist, www.danielatherapy.co.za, and an email address, daniella.riva@gmail.com, and a mobile number 066 154 7696. Daniella, am I right? Did I type it out correctly?
Perfectly right. Thank you.
You are welcome. Thank you very much. Daniella, we had this discussion a minute ago. Please, sometimes these videos get published and our viewers do not always follow us. Someone might watch the video today and totally new at it. So start out again for the next 5 minutes. We will be online only for about 45 minutes. Tell us about yourself before I continue with this webinar.
Thank you very much, and good evening to everybody. So I am Daniella. I am a psychological counsellor and a FAMAC accredited divorce mediator, as well as a court-appointed parenting coordinator. I run a family therapy practice and a mediation practice where I deal with all sorts of cases regarding anything divorce, parenting plans, care and contact, battles, maintenance issues, etc.
Sorry about that. I'm trying to share this on our other platforms. So, Daniella, you are well versed with family matters. I'm a legal expert, so I understand the law, the legal aspect of it. You deal with the issue concerning father, mother, child. You're on the ground level. You assess the matter. You can provide recommendations as to what is best for the minor child, what is best for the spouse, etc. I'm a lawyer. I know the law. I do not know that aspect. The judge will say exactly the same thing. The judge will say, I'm a judge, I'm a legal person. Yes, ultimately, I'll have to make a decision, but I'm guided by the experts. Thank you for that, Daniella. Going forward, everyone, please, we got limited time today. If you have a question, you want to pose it either to Daniella regarding parenting plans, mediation, or child custody disputes, please post it on our Facebook page. You are watching it, but make use of the Our Lawyer or the Advocate Mohammed Abduroaf Facebook page. Alternatively, if you cannot get to it today and you're watching the live video, please post it, and next time we're online, we will try to deal with that. Daniella, you have some real life scenarios, some real life issues before you. Could you kindly address it, and I will try my best to deal with it.
Yes, so what I thought that we would do is I deal with a lot of problematic situations where we kind of come to a standstill in terms of signing a parenting plan. And most of the time it's because one of the parents does not want to give up or give in. So they think that if they drag it along forever and they don't sign it, no matter how good the parenting plan is or how sound it is, that they never actually have to deal with the situation. So for an example, I have a client who has a minor child, and the child has got supervised contact with the father for various reasons that are completely applicable to the situation. But for example, now the father doesn't accept that, and there is no protection orders in place, there is no court order, there is nothing. So the situation then becomes very difficult, where we're trying now to mediate around why the father is bound to supervised access. The father will not agree to that. So what would, like, where I'd like you to come in a situation like this is, we have got fears about the safety of the child when the child is with the father. But what is our next step legally in terms of making that, presenting it to a court or to the magistrate or to whatever it is, so that you legally can weigh in and make the decisions that are right for the child?
Yes, then Daniela, my view on these type of matters, the moment the parties cannot come to an agreement, um, specifically in your scenario whereby there's nothing in place, there's no legal document in place, etc., and the parties aren't willing to come to that type of understanding and agreement, I urge people take the matter to court immediately, either to the children's court or to the high court. Get the judge to look at this matter and for him to make a decision. My policy always is, if you leave these type of matters to parties and obviously cannot be resolved, turmoil will happen, problems will arise. And police gets involved sometimes, people go off their rockers, they start, acting violently, etc. The matter needs to go to court. So if you can afford an attorney or an advocate, go to them, let them draft court documentation and take the matter before a judge. Tell the judge, these are the issues involved here. We cannot come to an agreement whatsoever, but the child is in the middle. Let the court make a decision. If you cannot afford legal representation, you have the option of going to the children's court. It's obviously much cheaper, you can represent yourself, but the processes are a bit different.
Right. And then, so yes, like I agree with you. And sometimes it's very difficult because a lot of the couples are in mediation purely because they want to avoid court. And even though they will not come to the party and mediate and sign the plans, they also don't want to go to court. So another thing that, I mean, I've got a couple of viewers now as well that kind of present this situation is, what happens if now we've gone mediation and, like you've said, we can't get to a resolution, or somebody doesn't even show up for mediation? We advise them to then go to the family court, yet the other party is still not willing to come to the party, misses court dates, is in breach of any orders that the magistrate might make. Then what is the next step then for that?
Now, obviously, somebody doesn't want to come to the table, to the court, and the court has proof that service of the application or the court date has been given to the other party, and documentation, what you're asking for from the court, has been presented to him, the documentation has been served on him, and he or she still decides not to come to court, and then the court will have to make a decision based upon the information before it. And if the information before the court is, well drafted, well explained, and there's a case on it, the court will more than likely grant the relief sought. So nobody can run away from the process. Maybe once the first time, but not the second time.
I think that's very reassuring, is that because I think a lot of people feel that the courts are so overwhelmed with cases that nothing's ever going to happen. And like the maintenance court, that is a perfect example. My advice is always just persevere. Yes, they are backlogged. Yes, they will get to you. But if you leave the system, if you do not go and try and fight it, nothing's going to happen. So to persevere with these things, and eventually it will catch up.
Yes. No, Daniela, you're 100% right. The difference between the maintenance process and a child custody process, regarding a maintenance process, the court needs to have both parties there. Let's say the mother requires a sum of 1,000 rand. It will be silly for the court, or improper for the court, to make an order against someone they do not even know where the person is, how much he's earning, where does he work. So the court needs to get into the court and ascertain from him, can he afford it or can he not afford it. Because if the court makes this a angry order, he doesn't want to come to court, I make it order of 10,000 rand per month, 1,000 rand per month. That piece, it's a piece of paper, it's useless because we do not know where this guy is. We do not know where he works. So it means nothing. And when he does come to the table in a few years' time, in a few months' time, for argument's sake, then he will say, but I wasn't informed, etc. Then the matter will get re-looked at. But regarding a child custody dispute, that's a different ball game. Usually it will be the party that, once obtained contact, will approach the court, and he or she will say, I would like to have contact, the other party is being unreasonable, please assist me. The other party is informed, he doesn't come to court, the court say, on paper, I see a case, I'll grant it immediately.
That's very helpful for, yes, that's exactly right. And I think that's very helpful for people who are struggling with this to realize that there is actually a light at the end of the tunnel. That it's not just going to be this. Yeah. Perfect. Thank you.
So, no, you're welcome, Daniela. So maybe where mediation and parenting plans come in, the law, the section 33 of the Children's Act specifically says that before parties approach the court, they need to try to agree upon a parenting plan. We have this new rule, form, I think 27 of the High Court rule, that specifically stipulate, before, when the parties start instituting legal proceedings, they need to inform the court that whether or not mediation is possible, and so on. So the courts are going towards mediation. I would advise parties, before you approach the court, please first try to mediate this matter, or obtain a certificate from a mediator saying, where the mediator will say, I've been approached by the parties, by the father, for argument's sake. I have contacted the mother refuses to partake in mediation with me. My certificates basically stipulate mediation did not take place. If the father has that document and approaches the court would say, okay, you have exhausted all possible remedies you have. Mediation failed. You are entitled to come to court. So then,
something that I keep telling my clients is that, I mean, keep your documentation, keep your track record, keep your trail record, everything you have. The more it can take a long time, and it can be heartbreaking at time when you can't see the light. But at the end of the day, the more information you can present to the court, the better. And when you have the proof that I have presented the parenting plan 4 times and it's been rejected each time, I have tried to see a therapist for my own personal issues, I have tried to make a meeting with the court. If you've got all of that attempt on paper, I think then it strengthens your case that you are really trying and you really have exhausted everything.
Now, Daniella, you stop thinking now like a litigator. You stop like a psychologist. You thought like a lawyer now, like a litigator. Well done. And also, we need counselors to know the law as well, to think logically as well, because it's useless knowing what's best for a child, etc. But you do not know the practical processes of. It's like knowing how to drive a car, but you do not know how to get your license. It doesn't make sense.
Exactly.
So, Daniella, my advice to people are, get your paperwork in order all the time. Build a case. It's silly for you to approach a court and say, the mother is refusing me contact and full stop. The court will understand there must be a legal basis for the mother acting that. Maybe she's being reasonable. Maybe you were the bad party because you're not elaborating it. But if you explain to the court, as you mentioned now, with a timeline, I have contacted the mother, I WhatsApped the mother, here's the emails, here's the WhatsApp messages, etc. The mother totally refuses for no reason. Clearly, your case will become stronger.
Right. And there was something else I wanted to add. Sorry. It's just completely, sorry, I'll remember it now. It's just completely gone out of my head.
So just for the viewers, the Advocate Mohammed Abduroaf Facebook page, that page is now live. I'm looking at it all the time. If you have any questions, feel free to pose it. Just type in my Advocate in full, Mohammed Abduroaf, into Facebook. The page should appear, the video is playing. Please post whatever questions you have. Daniella, I have a question for you. Oh, okay.
Yes, and then I remember what I wanted to say.
I will remember.
Sorry, I remember what I wanted to say. Is that just a tool for people dealing with this whole process of mediation is just to remember your place, and I say that with like great kindness and respect. But it's it's a tool to learn how to speak to people. And just to bring in another case that I'm dealing with, I have got a situation where the father is being refused access to the child because the mother doesn't like the family, and the mother has now put there on an affidavit or on paper in mediation that your family is no good for my child, and I refuse your access because of that. And he was like, what am I supposed to do? The bottom line is that what makes this person qualified to ascertain whether a person is a bad influence on your child? You can have your opinions, you can have your feelings, and that is what mediation is for you to be able to explain why you feel that person is not a good influence on your child. But you cannot base a whole custody battle on your opinion of the fact that you don't like somebody else. So it's important. It's going to be questioned at some point. What qualification do you have to determine that this person is not a good influence on your child, or is it a personal feeling? Because 99% of the time, it's a personal feeling. This child's granny gave him juice when he was 6 months old, and I didn't like that. Therefore, she's harmful for my child. Therefore, the child is not allowed to see her. It doesn't work like that. And that's where we have to deal with specifics of, let's talk in a group in the family system and explain to the grandmother how you feel. and why you don't like it as the mother. But that is no basis to cut any kind of access.
Danielle, it brings him back to the point and the law, where the law says the child's best interest is of paramount importance, not the best interest of the mother or the father. It's in the mother's best interest for the child not to have contact with the father's family because it does her good. She feels good at the end of the day. She's limiting contact. But is she focusing on what is best for the child? What is best for the parents is not necessarily best for the child. Daniella,
most of the time, in fact, it's opposite. What's best for the parents is not what's best for the child, and that's almost a rule of thumb.
And what I mentioned earlier in another webinar as well, that when it comes to the child custody matters, parents start acting like teenagers. Their logic goes out of the window. They start arguing irrationally, and they start wanting to bicker and fight over stuff that doesn't make sense. And the sad part is when they're older and they're working, they have money. So they can afford lawyers, they can afford to go to court, they have cars, they can drive. When they were younger, they never had that. Therefore, I tell my clients as well, please act maturely. You need to change your mindset. Act like an adult and we will get adult results. But if we're acting maturely and we're acting rationally, and I had a consultation with an attorney yesterday, and she told me sometimes the clients, what they do is, they tell the attorney, they send the attorney a long email, which is totally irrelevant in its content. They use the email in order to attack the other party and ask silly rhetorical questions and things which does not really assist in the finalization of the case. Now, that is very childish, and I would not even advise, if I get an email like that from a client asking me to forward to another party, I will say, if you want me to do that, I'll refuse. I will have to withdraw from this matter.
Yeah, absolutely. But that's the thing, is that also, I mean, my brother-in-law is a lawyer, and one thing very valuable that he taught me, which is valuable for life, not just valuable for law or for mediation, is whatever is going on, take a breath, sit back, sit with it, and respond unemotionally. When you respond to facts, or when you're writing facts, and this is the same for mediation, then you will get the results. The second you embellish it with all the unnecessary emotional responses, you kind of like lose your point, you dilute it as well. And then it's kind of just, it is designed specifically to attack the other person, and then they're going to respond emotionally. So what you said, it makes 100% sense. Get to the point, keep it simple, keep it straightforward. It can be yes or no. Can I have the child on my birthday? Yes or no? No. Why not? Because of A, B, and C. That's how it should be. It shouldn't be, oh, because last year when I wanted the child, you said no, and now your mother had the child on her birthday, so that didn't feel fair to me, so now I'm going to punish you. No. Keep it simple.
Daniella, I like your way of thinking. In all my litigation, I got this 40-page principle, in the sense of you get 40 pages of space in order for you to present your case. You can either use 30 of that pages to badmouth the other party, to mention a lot of irrelevant things, which totally will lose your case, but you're only getting 40 pages. I mean, I type on 40 pages, some lawyers only use 10 pages, but I think I need 40 pages to present my case. And they use it 40 pages, he done this, he had an affair 20 years ago, he was on drugs 20 years ago, he was an alcoholic. Before I met him, I found out that, he was suicidal, but they married for 20 years. The pages are riddled with all these things. Then later on in the documentation, do they provide some type of relevant information? However, the other party spends 39 pages dealing with relevant information, and there's one page saying that's all irrelevant information which the other party is stipulating. Guess who wins the case?
Yeah.
Now, Daniella, I've got a few questions for you, Daniella, regarding your mediation parenting plan. Now, how often do you apply your psychological training to a matter? Yes, obviously a lawyer can be a mediator, a legitimate mediator. Many of them mediators are attorneys, advocates, and so on. But using your psychological training and your education, how often do you apply that to a specific case?
100% of the time, 100%, and that even extends to the very first phone call, the very first meeting. I think when you step into a lawyer's office, you go in there with some sort of expectation. I've never met anyone that's gone into a lawyer's office just totally chilled and relaxed. There's some underlying expectation of anxiety that comes with it. So just from the sense of inviting people into my space and getting to know them, for my first session, I mean, that's what I do. I ask questions about themselves. We don't even talk about the parenting plan or the relationship or anything for the first 20 minutes. So even that is an application of trying to get into their comfort zone and into their space emotionally. So that is, I mean, that's why I say, like, even if it's a straight down the middle 50-50 parenting plan with absolutely no hidden tricks or anything, it's always psychologically influenced. And that is why I always say that the legal mediators definitely have their place, especially when it comes to maintenance. But a psychological mediator might, I mean, we can't just assume everybody's the same. So a psychological mediator might just make you feel a little bit more at ease, you know, when it's coming to the emotional component of the parenting plan. Maintenance is not an emotional component. Care and contact is.
Yeah, maintenance is mathematics, you know, how much you earn, how much the child cost, and so on. Daniela, I like using this example. If my door, let's say my office door is stuck, and I go to somebody who's uses chops wood for a living, or breaks down walls for a living, and I go to him, what policy, what principles would he apply? He will think, power, muscle. That is how I'm going to open this door. Or I go to somebody that's technically inclined, that uses, somebody that like closer skills to a locksmith.
Specialty carpenter.
Yes, a carpenter, yes, but he might not be a locksmith, but he's a carpenter. What skills will he apply? He will apply different type of logic, on how to open that door. Now, the same way when it comes to mediation, I personally, as an advocate, a family law expert specialist, I do not see myself as being an efficient mediator to a client. I will not. There are better people out there. Yes, sometimes I might have to mediate. They say we in a hot situation here, and the clients are in my office, and I need to know how to resolve issues. But I do not see myself as the best horse for the course. I would recommend that specific clients go to a specialist like yourself. When it comes to litigation, of course, come to me. I mean, I think I'm very good at what I'm doing, and I will do the best I can, and I will provide you the best possible results confidently. And do not go to the psychologist to litigate your case. We're two different horses. Therefore, with respect to all mediators, I'm certainly all of them are wonderful, but my personal opinion regarding me as a lawyer, that's why, Daniela, I didn't do any mediation courses. I mean, they are all available online quickly. You can attend a few courses, with respect, the proper timing, if it takes a month, 2 months, 6 months, whatever the case may be. Whereby for me, specialize in litigation, let the psychologists, the social workers, and those specific professionals specialize in mediation, facilitation, and parenting. What was the other word now? Facilitation and parenting coordinating. That's it. Yes.
Yeah.
Then I got another question, Daniela, if I may. So I see it a lot, Daniela, whereby a party does not want to mediate. And I have asked this question to you in a previous webinar, but this is a new webinar. How do you try to put a party at ease where he or she is not willing to, she ultimately will, but how do you get a party to feel at ease? Because a husband phoned you and says, Daniela, do you guys deal with mediation? Yes, we do. Okay, wonderful. He phones the mother. I found somebody. Oh my gosh, the husband spoke to you before the time. You are now tainted. How do you deal with that?
So the biggest problem is exactly that. The person who makes first contact is the person who the other party expects the mediator to be biased towards. So because I've spoken to the husband first, I automatically am on the husband's side, therefore I'm no good. And I do understand that. I mean, it's not the case. As a mediator, the main code of ethics is that we have to be unbiased entirely. And yeah, we're a third party there to just guide a conversation, to bring up relevant points. And we are not there to sit there and take sides and attack. That is not our job. Our job is to make sure that our clients come to an amicable agreement where both of them are heard without our influence directly based on one of the cases or the other. So what would happen in that situation, and again, this is why I always lean towards psychological mediators in terms of these kind of emotions, is the trick is to be able to make each party feel comfortable enough to know that they are not being attacked by the mediator, and that the mediator is not taking sides. I would then obviously sit down with the couple and I would start from the beginning. I would say, you know what? Yes, this person contacted me first. However, here is my initial phone call in notes and minutes that I've taken down. Here is an email thread where you can now also see exactly what was said. There is absolutely nothing secret. Everything is completely transparent. And then from there, if you now agree to it, but you still have a bit of reservation, I think it gets kind of eased in the sense that we sit down, I get to know each person individually, and I go back to logic. I remind a client that I'm not working for you, I'm not working for the husband. I don't care which one of you pay me. I don't care if it's both of you that pay me. I'm not working for you, I'm working for the children. And in that sense, I will always question decisions or scenarios that come up if to me it doesn't sound like it makes any sense in terms of the child. But when it comes to personal opinion and when it comes to what people have to say and what feelings they have, I will never weigh in on it saying, oh, that's not the right way to talk to him, because that is actually not what the situation is for. That is marriage counseling. And although I'm a family therapist and I do that, there's a very fine line and we don't cross over. So I think once people realize that I am not there to attack and realize that they can trust the situation, they can trust me, that's the difficult point. The difficult part is getting to that point. But once they realize that I am not there to take sides or attack, then they feel a lot more comfortable in opening up and actually embracing the process. But transparency is key.
I agree with you on that aspect. Transparency is key, and the other party will start feeling more comfortable immediately once he knows. And of course, the father in this scenario did not pay you any money because it's an initial engagement, and you will be afraid of taking any unless it's for advice, of course. But you're professional. You know what is required. You're responsible for your decisions, and the sooner people can realize that, the better. And even if for example, let's say court appoints a third party as a mediator, and one of the party in the court orders husband or father pays for it. Under those circumstances, you wouldn't feel as if you are being duped in. For argument's sake, there's a dispute. The court says an expert needs to be appointed. The mother says, no, I can't afford it. Father must pay. Court orders father to pay. Would the mother feel, unfair about it? No, she'll feel confident, this is a professional appointed by the court, as the case may be, or the parties agreed upon. But the father is paying for that. In your scenario as well, Daniella, I cannot see any bias happening from that specific point of view. Daniella, I got another.
Now, it's interesting what you said now, because I feel that when I'm appointed by the court, I'm viewed differently. It's almost like at that stage, the decision's taken out of our hands. We haven't seeked her out. The court has made it happen. Therefore, it's fine. Or the court says the father has to pay. Then the mother doesn't feel any problem because it was ordered by the court. But when it comes to somebody privately seeking me out for my mediation services, and then we have a situation where the father's paying but the mother's not, because my general rule initially is 50-50, because I feel that everybody needs to be accountable. If it's different, that's fine. So I've got a situation, for example, where it's 50-50. The father pays on time every time. The mother has never paid a cent. Every time a dispute comes up, it is always the same story. Yes, of course you're taking his side. It's because he's paid you and I haven't. No, actually, it's not the case at all. And if you read any of my reports or case files, then you'll understand that that's what the go-to is. Well, he's paid, so you obviously prefer him, therefore you're going to side with him, And that's not how it works at all.
It doesn't work that way. It's almost like, how can I explain to you now, the judge in court. Because the judge is, I'm using a silly example, white, colored, Indian, male, female, His decision, it's illogic, and that's where I go back to my scenario which I mentioned earlier on of this high school mentality. On all other aspects, corporate work, they might have wonderful jobs, CEOs of companies, but when it comes to these family dispute and these issues, all logic leaves the room,
Yeah,
and they start thinking,
definitely.
and it doesn't make sense. Daniela, you're a court-appointed mediator. You have a wonderful website, and you're an expert on these type of matters. I have spoken to another client, and these are different people that I've spoken to regarding you, and he was extremely impressed with your approach on how to deal with the child custody issues. And I would say a successful mediation process is largely determined by how professional and how experienced the mediator is. If you are an unexperienced mediator, of course you need to gain experience. Do not take complicated custody matters on. Take simple matters on initially so you can gain experience. But if you are inexperienced and you have a very complicated child custody dispute matter before you can, as a mediator, can mess up that marriage or that relationship. What do you do on that?
100%. I actually had a client that came to me after this exact situation where they found a mediator that was unfortunately inexperienced. The mediator gave legal advice, which again is not something, it doesn't matter if you're a legal mediator or a psychological mediator, we're not meant to give advice about anything. So this mediator was a counselor, and she had been mediating for about 4 or 5 months, and she took on this very complicated case and gave the most outrageous advice I'd ever heard in my life, and it caused massive issues. If it was mediated correctly, from the sounds of it, I can't guarantee it, but it seemed like it would have gone okay. But it ended up in full litigation because the advice was to go and seek out a protection order immediately when there were no grounds for it whatsoever. And it caused such a mess because there were no grounds for it. The mother went, got a protection order. The father obviously defended it. And then it caused huge issues with the mother's credibility and everything. It was just a disaster. We got out of it in the end. It took a while, but yes, definitely when it comes to anything, I mean, even back to the wood chopper and the carpenter, you're not going to hire somebody that doesn't know what they're doing. I mean, they're going to do more damage than good, unfortunately. And this is also a nice area where co-mediation is so important to me, is that my doors, I mean, I don't know if any other mediators watch this, but my doors are always open for co-mediations for people to gain the experience. They have to gain the experience somehow. And when you're messing with people's lives, then it's very daunting to gain the experience just on the fly. So I always do like to bring in, especially when I can work with like legal mediators who haven't been mediating for long, to invite them into a session just for another opinion, and obviously telling the client that we're going to have a co-mediation session. So you're also going to get input from another mediator. That's very useful as well.
Yeah, it's same like if somebody's been charged for a serious criminal offense. I'm not mentioning any examples here, where the potential is to go to prison for 25 years or 15 years and so on. And you are an inexperienced attorney or an advocate. This might be the first time you are dealing with such a criminal matter, and now you mess it up. The guy goes to prison for 25 years. You should not have taken on such a matter, or you should have had some guidance or assistance.
Exactly. And I'm going to expand that as well quickly, is that it's the same thing. Not only, I mean, we can go a level deeper and say, you're not going to hire somebody who's not a lawyer to come and defend you with that. The same way, you're not going to hire a conveyancer to come and deal with that. So you might have a lawyer, but it might be somebody who specializes in patent law. They're not going to, I mean, I've got a couple of people that I know that kind of like just jump around. And I'm not a family lawyer, but I'll help you, you're a friend. But they don't have the specialization or the experience in family law. Might be the most unbelievable criminal lawyer. The same way, I might be a psychological counselor that deals in family therapy. This is my jam. That doesn't mean that an addictions counselor is going to have the same finesse, even though we're all counselors. So that's also something to bear in mind, is that if you want the results, and this goes back to what we said earlier, if you want the results, seek out the right person.
So Daniela, our advice is not obviously going to the attorneys or to the psychological counsel. I mean, that is here to get experience. They'll do the job anyway. It's to the people
Yeah.
watching this video, the mothers and
Yes.
fathers. When you choose a mediator, psychological counsel, not us, anybody else, you look around, you go on the internet, you go on Google, you go on FAMAX websites and FAMS and so on. Find somebody who is experienced enough for your matter. If it's a simple issue whereby you guys just want to speak to somebody and obtain some type of clarity, then you do not have to go to anybody expensive or somebody that's in the entry level, that's fine. But if the issues are complicated, you presume the other party has some mental issues, you guys have been separated for many months, the child does not know the other parent, and so on. These are complicated issues, and the parties are miles apart. Both parties want primary care. The father wants custody, the mother wants custody. The father lives with the child for 10 years, but he wants the child to have overnight contact or spend half the school holidays. Those are complicated issues, and you need a professional to assist the parties in unpacking it.
And I think that all you have to do is, when you find a mediator, ask the simple question, how many years have you actively been mediating? Because if it's more than a couple of years, there is a guarantee that they've dealt with it at some point. If somebody says, I've been doing it for a year, chances are they've had 9 good, easy, simple things. And if somebody's been mediating for a couple of years, it's guaranteed that this has come up before and they've learned lessons from how to deal with it properly in the future.
So I'm a big advocate of people learning and training and empowering themselves, but I'm not a big advocate of people messing up cases. Daniela, in my office, honestly, I get parenting plans, consent papers that have been drafted 5 years ago. And the reason why I'm making money in business of these type of clients is because the previous lawyers messed it up. They wanted to get a divorce finalized for the client and beautiful, I mean, it's wonderful. The guy wants to get divorced. He gets a divorce order. He's now single. 6 months, a year, 2 years down the line, issues arise. Then he thinks, why did I not get a proper lawyer? Then the attorney will say, easily, this is my instructions. You provided to me. You signed the documentation and so on. But the problems are not, it doesn't arise today. It arises in many years from now. And you can't blame the lawyer. You have to blame yourself. So get the proper horse for the proper course.
I think also, I might be wrong, but from my point of view, I feel that lawyers generally get more trust up front from their clients. I know, like, if you think about it, if you're going to sign a lease and you take it to your lawyer and to say, look over it, and they say, yes, it's fine. People sometimes just say, okay, well, my lawyer said it's fine, I'll sign it without even reading it, So you've got that immediate trust because lawyers know what they're doing. And then on other aspects, like with psychology, my father, for example, was never a fan of psychology as a industry. He doesn't understand it. So if he were to go to a psychologist and say, this is what's going on, this is the problem, he would sit there and question and question and question until he felt like he was comfortable with the answer. But going to a lawyer, it would be, the lawyer would have to say something once and he would be happy with that. So I think, I don't know why I'm telling the story, but I think that it's also valuable to realize that everything is a process, and that, once you get involved, if you feel like things are going right and everything's working out fine, then to just embrace the process and trust it.
Now, Daniela, on that point, and I'm glad you mentioned it, many times clients will approach me and say, I want a male lawyer. That's why I want you, because the other party got a male lawyer, or I want a female lawyer that's tough and as whatever the case may be. And I do not necessarily see the logic. If you're good, you're good. If you're bad, you're bad, and full stop. It doesn't make a difference whether or not you are male or female, black or white. That's just my personal opinion on that matter.
Next to going to university.
Yes, exactly. But Daniela, just on a side note, I believe you're working on the LLB. Good luck with that, and maybe I'll see you in court soon. That'll be interesting. It'll be exciting. It'll be nice. It'll be interesting in the sense of your old colleague. Now you're up against in court. But it's nice. It's nice. Daniela, moving on the specific topic, and I'm focusing on mediation and parenting plans because we that's what we're discussing. If you are watching this video and you want to find out about parenting plans, there is a video of last week which Daniela provided a link where you can download a parenting plan and she discussed a parenting plan. So that is in last week's video. If you're watching it on YouTube now, please remember, let's go last week on the same channel and you'll find those videos. Daniela, we got another 10 minutes left. I mentioned that we're knocking off here this week before 6 o'clock, 10 to 6. On the issue concerning parenting plans, I believe that every parenting plan must be unique to the specific parent's situation, and it must be workable and a workable document to work with. How often do you see parenting plans that are very badly drafted and causes more problems than finding solutions for the people?
So I see that relatively often. And I wouldn't really say that they're bad parenting plans because the bones are there. But the thing that is not there is the embellishment, and that is often what causes the fight. What I mean by that is they've got in their bad parenting plan that each parent is going to have 50-50 access. Perfect, signed at 50-50. But they don't stipulate how that time is going to be divided between the two parties. So the embellishment of that is missing. So it is not a wonder that we have issues arising when it comes to the child's birthday, where the only thing on the parenting plan says is we will share the day with the child. We'll each have some time. It doesn't say how much time. It doesn't say where the child will wake up. It doesn't say anything. And then we have a fight. Oh, well, I really wanted her to wake up with me on her birthday. And the father says, well, I wanted her to wake up with me. Okay, well, let's go back to the parenting plan. Look, oh, we didn't get to that. So in terms of a well-drafted parenting plan, the more information you can add and the more like real fact. So on Mother's Day, the child will wake up at mom, not will spend the day with mom, because that means at what time the dad drops off at the mom is acceptable. The child will wake up at mom for Mother's Day. That automatically means whoever's night it is, the night before Mother's Day, the child will be with the mother. And that's agreed upon, and the same for Father's Day. Christmas Day, mom will have the child in 2020 will wake up on Christmas Day at mom, and then we'll take to dad at 12. Similarly, in 2021, the child will wake up with dad on Christmas Day. The more information we can add, the better, because that avoids any further dispute in the future. So again, when it comes to a badly drafted parenting plan, we see it often enough because there's just not enough information.
Now, Daniela, this brings us to my attention, or I think about the scenario. Let's say that specific scenario which you are referring to, that one clause that the parties will share the minor child 50-50 school holidays and during the month, that clause in the parenting plan. But this specific couple, they went for mediation, for counseling before they entered into that bad parenting plan. They discuss these issues. They discuss, how they're going to resolve it. They discuss matters before the time. And they have agreed before they entered into that specific parenting plan that whatever needs to be done, they will email each other, they will, communicate with each other. But now they have a bad parenting plan. As opposed to the other couple, they were separated for a year. They never chatted to each other. They do not speak to each other. They got two top-class lawyers on board here to draft a nice parenting plan with those specific, ununderstandable clauses. They signed it, advised by the legal representatives, and they moved on. Obviously, you'll agree with me that the parties that went for mediation, no divorce counseling before the divorce, would have less problems than the parties that just signed the document and
100%. I mean, they've had the opportunity to unpack and to deal with issues, before they become issues, what could potentially be the issue. And this boils down a lot to respect. Like people who, even though they're struggling in their relationship, can still respect each other, then they can actually do these kind of things and they can go and resolve them first. So yes, like to be able to do that and to be able to do a parenting plan with a genuine interest in your child, where you don't feel like you need to attack each other because you have understood. A couple get divorced, and I do divorce therapy. I don't necessarily do relationship therapy where we have issues in the relationship that we're trying to solve. I have a lot more clients that we are getting divorced. We have decided on this now, but we want to work on our co-parenting relationship. We want to work on the terms of our relationship in terms of the divorce and what we can expect going forward, because we don't want to have issues like this. So once you have had that opportunity and you can come to the party and in a relaxed, unthreatening way sign a parenting plan, I mean, it's the greatest wish for a mediator. But I kind of wish sometimes that there was a prenuptial arrangement that people could sign the same way they do. Like, what is going to happen if we get divorced with the money? and they're on good terms. We're excited, we're going to get married, this and that. If something were to happen, this is what we're going to do with the money. Wouldn't it be amazing if we could say, provided you live up to being safe parents in the future? Would it be amazing to have a prenuptial agreement or a parenting plan should the marriage break apart? Where you say, okay, well, at the time when you liked the person and you felt that there was a good mother, everything was fine. Now that you're bitter, now everything's changed. It's the same thing.
Daniela, I like your idea very much. The challenge would be, and the easy idea to implement, you have the property aspects out of common property with or without accrual, and you put those nice clauses in that many lawyers put in. And then you put additional addendum there too, that should we become parents, this is how we'll parent the child. But Daniela, once parties separate, they become illogical. Their mission is they want to fight and they want to annihilate the other party. But I like the idea, and I'm not discarding it or discounting it at all. And
you know what? Based on that as well. Sorry to cut you off, but because of the prenuptial agreements, and I'm just specifying that. I mean, we do have situations where it's not in play. Because that's been signed and it's very specified, there is really nothing left to fight about other than the child. So that is, I think, why the custody battle becomes so heated, because it wasn't signed before. It's not cut and dry. It's not just you owe me 27.60 and I owe you 13.40, end of story. So it gives them something to fight about, unfortunately for the children.
And the nice thing about it is, if problems do arise in the marriage, the parties will actually go to the document and say, there's problems, these are how we should resolve it. So before they even go to the mediation or the divorce process, there is something to work with. Daniela, that is it. We have to cut this video short. We have stuff to do. For those who have watched this video, thank you very much. Daniela, we will stream it again later tonight or tomorrow. I think tomorrow we'll do it again. Daniela, thank you for your time. Your details are on the screen. Any final words before we cut off? And we will be online again next week. Any final words?
No final words. Just have a good evening, and thank you for watching. And if you've got any questions or anything you want us to discuss in the future, I think then to just send you an inbox maybe, where we can actually talk about anything that you might have that's going on.
Wonderful. Daniela, your details are on screen. They will be on the video on Facebook and so on. Your website, your email address, and your mobile number. People can WhatsApp you, but please just WhatsApp Daniela and mention, you put your name at the bottom, that who you are and how you got the details, and she'll definitely respond to you. Have a wonderful evening, Daniela. I won't chat you after this video. We cut him off, and I'll see you online next week, and we'll chat soon. Thank you.
Thanks so much.
Bye-bye.
Bye.